I haven't expressly thought about it as connected to this project, but I think that there's one other kind of way of critiquing the dominant tradition in our field, which is to think about the way they use examples. So, for instance, I think in kind of classical legal philosophical treatment of criminal law, there's the spectre of the slave. So the slave is the kind of classic unfree person, and that someone is used as an example for thinking about the value of autonomy, etc. And yet, I suppose, coming from an Antipodean perspective, I think there are many other ways of being unfree, racialised selves, gendered selves, etc. And I've always wondered whether somewhere in my future is a kind of project where I actually look at those legal philosophical studies for their use of examples, and think about what kind of purpose and way in which those things are told. Because I guess, yes, slavery is an important kind of point of dialogue for legal philosophical studies, but there are so many other ways in which one might think about the role of the modern criminal law as promoting autonomy and selfhood, etc. It's a very direct way of answering, except to say I think that I will keep this tension in my mind as I go through, because I don't want to stop talking to the legal philosophers, and I'm hoping to be able to speak coherently to the historians, but it's quite a challenge to try and do that.